Wonderful. All right. Okay, and right from the top, can everybody see that okay?
Yep.
All right, wonderful. Well, Sarah, thank you, and thanks everybody. My two favorite things, presenting to the CFCA and presenting with David Kaminski. So thank you all for having me. I'm Kevin Rupy. I'm a partner at Wiley, very focused on the robocall issue. And I'm thrilled to have with me David Kaminski, who is Mr. TCPA. David.
Way too kind. Good morning, everybody, and thank you for tolerating us this early in the morning, at least on the West Coast side. Thank you so much, Sarah and the CFCA. We have a lot to tell you. So big stuff is happening in our world, in our calling world. Just very quickly, legal disclaimer. As you know, this is not legal advice. We're just trying to provide you with the most accurate information that we can, up to date with respect to the topics that we're discussing. But of course, you should consult your own lawyers or us later on if you should need any help or advice on any issue.
And with that, we've got a jam-packed agenda. We're going to move through this at a fairly high level, but we'll save some time for Q&A. But today, I mean, topic number one, Facebook DeGuide, obviously the hot topic right now. David is going to give some insights on that and then turn to the constitutionality of the TCPA, some issues that have been developing there. I will then step in and talk about the dramatic activity at the FCC in 2020, sort of what's happening in that space. And where worlds collide, robocalls and TCPA, David will cover the FCC's TCPA order. I'll wrap up with some recent developments on robocall enforcement, and then we'll turn to Q&A from the audience. So with that, I will turn it over to David. David, Supreme Court, Facebook, TCPA, a lot going on. Walk us through it, sir.
It is. It's a big day here. So look, all of you know it's no secret right now. So this is old news. April 1st, Supreme Court issued its opinion in the long-awaited Facebook versus DeGuide case. I think I got it backwards there. And so what did the court say and what was the issue? Well, they were going to determine, the whole issue in the Supreme Court was, what is the definition and the interpretation of the definition of that phrase, automatic telephone dialing system, in the TCPA? Kevin, go one slide and then I'll come back.
Sure.
So look, all of you know that this definition is in the TCPA about what is an auto dialer. Was equipment that has the capacity to store or produce numbers to be called using a random and sequential number generator. That has been what is deemed to be an auto dialer under this Telephone Consumer Protection Act law. And it's illegal to make a call using an auto dialer, this ATDS, without prior express consent if you're calling a cell phone or if you're leaving those pre-recorded messages. But this really focuses on the auto dialer definition. Let's go back. So the Supreme Court finally, Facebook versus DeGuide was a case in the Ninth Circuit Court of Appeal. And of course, the Ninth Circuit Court of Appeal, in interpreting what was Facebook's sort of text platform system, basically said, okay, we're looking at the Marks case and we are constrained by the Marks 2018 decision. And that says that a auto dialer can be that equipment which basically stores and then automatically dials number. That's how broadly the Ninth Circuit had interpreted the auto dialer definition. Of course, reverberations throughout the country. You had conflicts from the Seventh Circuit Court of Appeal, from the 11th Circuit, from the Third Circuit versus the Ninth Circuit, the Sixth Circuit, and the Second Circuit about what is an auto dialer. Here it is. Supreme Court resolved it. So to qualify as an auto dialer under the TCPA, a device has to have either the capacity to store a telephone number, that's a storage function, using a random and sequential number generator, or to produce a telephone number using a random and sequential number generator. The bottom line and the common denominator is that random and sequential number generator. Next 2 slides, your system has to have it. That's the basic and the bottom line of all of this. And this has sent reverberations and shock waves, not so much as far as expectations. I think it was pretty clear during the oral argument in December 2020, when Justice Sotomayor said, really from the get-go, her first comment was basically, well, isn't this just antiquated? Isn't this an antiquated statute that doesn't really deal with modern day current technologies and calling and dialing technologies? And the answer to that was yes. And isn't it true that we as Congress, as much as we'd like to, we can't fix this problem? This is a congressional problem. We don't fix statutes, we just interpret them. And that basically was it. So once Sotomayor said that, it was clear for me, okay, we're at an 8-1 decision at this point. And I had lectured, I said, this is going to be an 8-1 or a 9-0. I didn't quite expect the 9-0, but I'm not surprised at all. So really a terrific decision. The decision, I think I've been advocating this interpretation of an auto dialer, oh my God, since 2006, when I was one of the first in the entire country to have a TCPA class action. And people said, hey, what's this? So look, we got this fantastic definition. It is really going to be a game changer here. People did expect that our phones would start blowing up left and right after this decision. In fact, can I tell you, it's interesting, my phone started blowing up like crazy within 2 hours after that oral argument and in the Supreme Court. And maybe it's just coincidental, but I started getting more robocalls that day than I had gotten in a long time. And it could have been coincidental. But anyway, that's basically where we are. So what happens now? Where do we go from here? What does this all mean? And what does it mean for companies? Okay, look, in short, most of the equipment that I'm sure that you are using, or that the telephony vendors are using to, quote, call customers, to call people, to even telemarket, do not have random and sequential number generators. People got smart when this law came out in 1991. They took out their random and sequential number generators way back then. So, but this is the time really to take a step back, to take a breather and say, look, if I'm making calls or my clients are making calls, what do I have to think about? Well, it's vetting your technology, vetting your whatever auto dialed equipment that you may have, no matter what kind, and determining whether in fact that system does have random and sequential number generator capability or capacity. Interesting, the Supreme Court did not deal with the issue of capacity, but noted that, hey, capacity is out there. It's the capacity to store numbers using a random and sequential number generator, or to produce numbers using a random and sequential number generator, and then to dial them. And the way the Supreme Court talked about it, they were talking about the equipment basically as one entire package. They weren't talking about, and this remains to be seen how this is going to play out. They weren't talking about having a system on the 5th floor which randomly and sequentially generates numbers, and then you run downstairs, you download that into your auto dialing equipment, and then you start auto dialing from that equipment. So this issue about the random and sequential number generation is going to maybe be one of the fights. The issue of capacity is out there. What does capacity mean? As many of you may recall, capacity was deemed to be present capacity by most of the federal decisions that were interpreting the TCPA. So they said, does your system have the present capacity to do X? Not that you've used it at the moment. And case law has clearly said capacity doesn't mean the physical actual use of it, but the fact that the ability to use it, the fact that's there is is key. So remember that. With regard to this decision didn't touch that phrase in the TCPA dealing with pre-recorded and artificial messages. And that came in the fact that it's illegal to make a call using an automated telephone dialing system or a pre-recorded or artificial voice message to a cell phone without prior express consent. So that "or" is a critical word. Most cases throughout the country for years have always concluded that the delivery of a pre-recorded message, no matter what method, is used to do that. If you were launching a call with a pre-recorded message or an artificial voice message, that could invoke TCPA liability, having nothing to do with the auto dialer function. You don't have to have an auto dialer that delivers a pre-recorded message. Some companies say, hey, my auto dialer, if you think that's a predictive dialer, my auto dialer does in fact deliver my pre-recorded messages. Doesn't matter, because that is an "or" that is separate and apart from the auto dialer issue. The auto dialed issues is to make a call, and a call is a call, like a voice call. The ability to communicate with someone in real time via a telephone. That was the Satterfield decision. But then you also have the text message component. Is a text message a call? Yes. Satterfield says it was. That's a Ninth Circuit decision that most courts throughout the entire country have agreed with. The FCC has agreed with, and I don't know of any cogent law that successfully has rebutted that or challenged that issue. So a text message is the call. It's the same thing as a call. So if you're using text messages as a way to communicate with whoever you need to communicate with, your customers, consumers, etc., any type of engagement, then your text message platform needs to be seriously looked at, just like your auto dialing platform, to determine whether that system has the random and sequential number generator capability, either as a storage function or can actually produce numbers in a random and sequential fashion, because it's got a random and sequential number generator. So my God, look,
a lot of moving parts, David. Can I ping you with a question?
Sure.
I keep hearing a lot about this footnote 7, and that is drawing a lot of scrutiny from folks on both sides of the argument. Could you walk us through that?
Sure. So footnote 7 is a footnote within the decision, of course, and that's where the Supreme Court started talking about whether that those word produce numbers or store numbers is one of those definitions or those words superfluous, right? And does it mean something else? And can this bring other technology into the fold that maybe the Supreme Court didn't intend to be brought into the fold? So early on in the oral argument on this, in the Facebook decision, the Justice Roberts made it very clear. He clarified that the word storage is not a superfluous word, because a random and sequential number generator, even though generally not used for a storage function, does have a storage capability. It also has the production of numbers capability. So once he said, okay, there's no words that are superfluous in the TCPA, which caused us to completely rethink our definition, then he tossed it over to Justice Sotomayor to make her comments. So one of the issues was that someone had picked up. They said, hey, look, an auto dialer may use a random and sequential number generator to determine just the order in which to pick numbers from a pre-produced list, and then to store those numbers. So then, do you have an auto dialer in that regard? In other words, the plaintiff's bar is looking at footnote 7 and somehow thinking, and I say somehow because I think it's far-fetched, but they're grabbing onto anything that they have right now on the TCPA because they've lost a lot. They're thinking that somehow a predictive dialer that just stores numbers and can, you can download a pre-produced list of numbers that are random and sequential, that somehow equates to an auto dialer. But that's not how I read this, because in footnote 7, the Supreme Court made it very, very clear that you have to have a random and sequential number generator as part of your equipment. It's got to be part and parcel of the equipment. And sometimes they said, hey, look, a storage function and a producing function, those could be separate, but they could merge. You could be using a storage function or a production function, and you could be using them together, meaning that your random and sequential number generator can produce, can store. The bottom line is, if your system doesn't have a random and sequential number generator, then you have an argument you don't have a dialer. But otherwise, generally you would. So nothing is going on with that decision, and with that footnote 7, and I don't think that anybody could make anything of it, because the Supreme Court was pretty clear, even within that footnote 7, that they're talking about equipment that has a random and sequential number generator.
Okay. All right. So, well, thank you. And keeping this moving in light of time, a lot of other stuff going on in TCPA world, right?
Yes, Kevin, yes. So very quickly, just before I move ahead, very quickly, the whole concept of human intervention, which the FCC created as an end run around having an auto dialer years ago, said if you're using human intervention, you may not have an auto dialer. Supreme Court threw that out. They said, look, we're not going to create some kind of line drawing phrase that doesn't even exist in the TCPA. And forget about that human intervention. Human intervention is not going to take an auto dialer out of the auto dialer purview just because you're using human intervention. If you're not using an auto dialer, that's one thing, but they're not going to allow anyone to get into this, human intervention issue, which then would create litigation just to determine whether or not you did use sufficient human intervention in order to bring yourself outside of the purview of the TCPA. So this was a gut punch to the FCC. They basically eviscerated every one of the FCC decisions regarding interpretation of what's a dialer and how do you do an end run around using your auto dialer. So just moving forward, and look, we can expect new laws to come out. We can't be naive about this. Next slide. Senator Markey has already talked about the fact that fact that he thinks this law is horrible. He doesn't think that's what it was meant for. He says this was meant to stop the proliferation of auto-dialed calls, period, whether it's made by a random and sequential number generator or otherwise. And the Supreme Court saying we're not necessarily disagreeing. Sorry, that's not what this statute says. So that's the problem here. But Senator Markey of Massachusetts and others throughout the country are working together. Various assemblymen and congressional folk in California are looking at AB 3007 to bring that back to life, which was a revision of the California auto dialer law, which had no teeth, but it may have teeth because it was literally worded exactly to mirror the Marks Ninth Circuit decision. It was killed about a year ago in committee due to pandemic issues. Who knows if it's going to raise its ugly head again? So we shall see. So much going on. Very quickly, the Barr decision. I know that you all know this decision. This just determined whether that federal exemption for collection calls that were made on behalf of the U.S. government, that particular phrase that was amended to the TCPA and said if you're making calls on behalf of the U.S. government for a payment or other purpose, then you do not have to have prior express consent under the TCPA. That was deemed to be a content-based revision to the TCPA. The Supreme Court easily threw that out. And so the next question, next slide. So the next question is this: is the TCPA now unconstitutional as a result of the fact there was an unconstitutional provision in the TCPA all the way from 2015 until it was struck in July 2020. And that's the question of the day. There were, and what people are springing from, it looks like Justice Kavanaugh on the Supreme Court, who is what I call our severability guy. He says, hey, if there's a severability provision in the TCPA, meaning a provision that says if there's one part of the statute that's bad, just try to sever it out, but try to leave the rest of the statute intact. That's the Kavanaugh theory. It says don't strike your whole statute, try to keep Congress's intent in place. But then there's Justice Gorsuch and his little team who said, oh, if you had an unconstitutional provision in the TCPA, then that entire TCPA provision was unconstitutional during the period in which the unconstitutional revision was in there. They said, so the unconstitutional provision was in the TCPA from 2015 to 2020. Guess what? Under our theory, the entire statute, the auto dial statute and the consent statute was unconstitutional at that time. Next slide. This has been bandied about by many cases so far. People have been challenging the constitutionality, starting with the Eastern District of Louisiana case called Creasy. Creasy was the first case really to look at this and say, hey, you're right. The entire TCPA prohibition on calling auto-dialed calls is struck, in our view, because it was unconstitutional during that 5-year period. So if you have a case that is based upon a call that was made within 2015 to 2020, before the Supreme Court struck the provision, that case is unconstitutional. Well, next slide. It looks like right now there are 9 decisions that are out there so far. There may be a 10th that have dealt with this issue. And it looks like the vote is sort of a 63 in favor of not deeming the TCPA unconstitutional during that 5-year period. As the Supreme Court said in the Barr case, look, what we try to do is save statutes. And they even said, this is a good statute. It's really done its job for whatever, almost 30 years now, since 1991. So why would we really mess with it? We can sever this one bad provision out, but leave the entire statute intact. Congress's intent to stop the proliferation of prohibited auto dial calls. So that's basically where this is going. I think that the majority of those cases are going to ultimately hold sway, and that the TCPA will not be ultimately deemed constitutional. There's one court right now that is going to deal with this. The first court will be the Sixth Circuit Court of Appeal, who will be listening to arguments on whether the TCPA was constitutional for that 5-year period. Knowing the Sixth Circuit and the way that they generally rule, we expect that it's going to come out in favor of the majority of the 6 cases that it ruled that it's not unconstitutional during that period. Just that provision was unconstitutional. So that's the fight. We'll see how it goes. And I'll tell you, every day there's a new surprise. So fasten your seatbelts. And with that, I turn it over to my esteemed colleague, Kevin Rupy.
All right. Well, thank you. And speaking of fasten your seatbelts, let's talk about the FCC and activity that's been taking place there. And folks have had their seatbelts on since passage of the Trace Act. Bottom line, passed in late December 2019, right at the end of the year. The FCC has just been issuing orders left and right, nonstop. And notably, a lot of these orders include mandates for voice service providers. So we are, shifting from, in the robocall space, which David and I distinguish from TCPA, we are shifting from the FCC taking a more permissive approach, permissive blocking, to mandates, and we'll talk about some of those. We've got the mandate for Stir Shaken, June 30, 2021, that is rapidly approaching. All voice providers, if you originate or terminate voice calls, or both, You will need to file certifications in the FCC's forthcoming robocall mitigation database. And we'll talk about what that is briefly. And the bottom line, and we've already seen it, robocalls are going to remain a priority issue for the FCC. Acting Chairwoman Rosenworcel has already indicated that. So let's talk about some of the key orders, and they were in 2 dockets. So you're going to see, I refer to first report in order and fourth report in order, but they're in 2 dockets, so the numbering won't match up. But right out of the gates in March 31, 2020, the FCC mandated implementation of caller ID authentication, stir shaken. And what they require of voice service providers who are implementing the standard, you've really got to think about this in sort of the 3 calling scenarios. So that one in the hole, if you're a voice provider that's deployed stir shaken and you originate and terminate a call that stays on your network, doesn't leave your network, you've got to authenticate and verify that call authentication, the caller ID information consistent with the standard. If you originate and exchange a call that's going to terminate on somebody else's network, you've got to authenticate the caller ID information and then transmit it in accordance with the authentication standards to the next voice service provider or intermediate provider in the call path. And then the third scenario, if you're terminating a call, so you didn't originate it, you didn't transit it, but you're terminating it, you've got to verify that caller ID information. And that was the FCC standard for implementing what it means to implement the stir shaken standard. June 30 deadline coming up.
Kevin, quick question.
Yeah.
Because of this complication and this authentication and verification requirement, and because of the not perfect analytics that are doing this type of authentication and verification, can you just list quickly, and I don't want to derail you, but just all the types of problems that you can see happening with this verification and authentication, even to good actors?
Yeah, that's a great question, and I'm going to hit some of that in the FCC's third report in order. But one thing I would note for call originators to that point, stir shaken in isolation will never be used by anybody, an analytics provider or a voice provider, to determine whether a call is good or bad. There are some imperfections in the analytics side, but there are also important distinctions between blocking and labeling of calls. And we're going to hit some of that because, to your point, David, the FCC realized that they don't want legitimate calls blocked. They only want the illegal calls blocked. So the next step we had was in the 1759 docket in July, third report in order. 1759 kind of deals with those issues that David is talking about. And this hits the very point he was hitting or addressing. But what the FCC did in its third report in order, it created 2 new safe harbors, consumer opt-out blocking based on reasonable analytics, that it has to include stir shaken, but it should also include other things, human intervention, analysis, things like that. They also created what's called a bad actor provider safe harbor. So a downstream provider can basically block all of the traffic from a bad actor provider that's passing bad traffic. And the FCC recently exercised that authority on some cease and desist letters it issued. To your point, David, about protections against erroneous blocking, and this just applies to blocking, voice providers have to implement certain things like a point of contact, publishing contact information, investigating and resolving blocking disputes to that point. So if a legitimate caller says, hey, you blocked my call, but I've got consumer consent and this is legit, there's a mechanism in place to address that. So that was in July, but really the Mac Daddy of orders that came out was the second report and order in October. That established caller ID authentication obligations in non-IP networks. So TDM networks, voice providers who are operating in that space have to work towards a solution on authentication. The FCC also exempted and established extensions for the June 30, 2021 deadline. We'll talk about that. A provider that receives an extension, so that gets an extension, they've got to put in a robocall mitigation program that is focused on ensuring that bad calls don't originate on its network. And then we get into the robocall mitigation database. And to that point, the FCC in the second report and order, it's going to prohibit intermediate and terminating providers from accepting traffic from voice service providers not in the database. So if you're not in the database, intermediate providers and other voice service providers are prohibited from accepting your traffic. That is a major development. You know, it could effectively put a voice provider out of business. And the FCC has also applied that to foreign providers. That rule will go into effect 90 days after the certification filing deadline, which probably around September 28th. At this point, maybe into October potentially.
Kevin, someone had a good question that you in part answered, but maybe you can just expand for a second here. How does a VSP authenticate or verify a call that is going to originate outside of the U.S.?
So that goes to the FCC's foreign provider prohibition. And basically what the FCC did, they did kind of a sleight of hand. They are going to require foreign voice service providers, and there's some ambiguity around that term.
Right.
They need to register in the FCC's database. And in so doing, they're subject to the same requirements as other voice service providers. So they either have to deploy Stir Shaken or develop a robocall mitigation plan. And
if they don't, Kevin?
If they don't register in the database and they are a voice service provider, now keep in mind that is a provider that originates traffic. The gateway, the first domestic point of entry, can't accept their traffic. But if you think about the foreign interconnection piece, you know, my understanding is it's pretty rare for a originating foreign voice service provider to directly hand traffic to a domestic gateway. In other words, that traffic generally, especially for roaming traffic, goes through an intermediate provider. And a strict reading of the FCC's rules indicates that those intermediate providers aren't subject to that certification requirement. But there's actually a petition for recon that's been filed on that foreign provider prohibition. There's a lot of questions about it. And, you know, we'll see when and how the FCC acts on this. Real quick, these are the 4 extension categories: small voice providers, incompatible with SIP, pending 214, inability to obtain tokens. These are the categories of providers that will need to implement a robocall mitigation plan and certify as such in the database. Each is subject to different extension periods. But keep in mind, if you fall into one of these categories, you're out of the Stir Shaken obligation, but you have to do a robocall mitigation plan, and you will have to certify in the database.
Kevin, quick question.
Yeah.
Does the FCC require that all terminating carriers use analytics to either identify or block or limit calls?
No, all blocking by voice service providers is permissive.
Okay.
with the exception of the database. You can't accept traffic from a voice service provider, okay? Keep in mind, voice service provider that is not in the database. So that's really the only instance of affirmative blocking. But to that point, to affirmative obligations, fourth report and order, it hit Federal Register notice yesterday. So affirmative obligation on all voice service providers. You got to respond to tracebacks. You got to mitigate traffic when notified by the FCC. And that third one, you have to prevent new and renewing customers from originating illegal robocalls. The third thing, and this goes, David, to what you raised earlier, Safe Harbor is expanded to network-based blocking based on reasonable analytics. And to that point, the FCC placed obligations on any voice providers that choose to do so. So they've got to maintain a blocked calls list. They have to have, call blocking, dispute resolution, point of contacts. There's no redress requirements for labeling. They have to give an immediate notification of blocking, whether through SIP or TDM. That one is very technologically complex and a lot of questions on that. On the mitigation plans, I'll hit this very quickly. FCC takes a non-prescriptive approach. So for those providers with an extension, they've got to ensure that none of their customers are originating traffic. And that's a key point. This is all about traffic originating on their network. Those voice providers are going to need to document and certify how they're complying. And the FCC's Enforcement Bureau, if you're deficient in that space, they can come knocking and basically rewrite your plan. So with that, David, I know we've had some TCPA stuff at the FCC.
Yes, we have. Very quickly, someone asked the question, does the Degweed versus Facebook interpretation of an auto dialer mean that there will be more, let's say, legal robocalls or illegal robocalls that will now be legal? It's a fantastic question. And it is the question of the hour. It's interesting that you use the word robocalls, legal robocalls, because guess what? That terrible moniker, and I'm not faulting the requester who asked that. I'm just saying that that terrible moniker has been used by the National Consumer Law Center and all of the different, let's say, trade organizations for consumers to make every call look like a bad call, no matter what, if it's legitimate, not legitimate, it doesn't matter. They call it a robocall if they think you're using auto dial technology. And that's terrible because you know what? That got into the lexicon of the Supreme Court when the Supreme Court was hearing oral argument on Degweed and Facebook. And they even use that word in their ultimate decision, not too many times, but they use that word in the opinion. So that's just a terrible thing that's happened in our country. So even legitimate actors are being deemed, oh, you're using auto dial technology, you're making robocalls. That has that bad moniker of bad actors doing bad telemarketing. That's not what it is anymore today. It's gotten into the American lexicon as a normal word for every type of call that you get, basically. So the auto dialer law, the new interpretation, certainly would have the effect of opening up the floodgates for good actors and bad actors. Why? If everyone is saying, oh my gosh, the sun has come out, guess what? My auto dialer that I want to use or have been using, it's not an auto dialer anymore. It does not have random and sequential number generator in there, and it can't store and produce numbers. I'm good to go. That means that I can start making calls all day, and I don't have, for informational calls only, I don't have any restrictions except for some, various states' laws dealing with state calling limitations, et cetera, or other federal statutes that restrict a certain number of calls for a particular group or trade. But other than that, it's let that baby rip. And I mean that in a very colloquial sense. For telemarketers, what they're going to say is, oh my God, I'm not using an auto dialer anymore. I don't have to worry about the TCPA? Well, they do from the do not call list, because the do not call list part of the TCPA for telemarketing is agnostic. It doesn't matter what kind of method that you're using to make or deliver the calls, that if someone is on the DNC list, you have to follow that. And after one call, you're sort of one free bite at the apple. You have potential liability. So they have to worry about the DNC. But let me just tell you, a lot of back actors, they go DNC, SHMENC. They don't really even care. They're just ignoring that and saying, I'm not using an auto dialer. I am just going to make those calls. And for these foreign callers that we cannot literally, and Kevin's going to tell us a little more about, we really can't control them. They have ways to get their calls through. Will stir shaken? Will the call blocking order help, or a combination of both? Who knows? But we those calls are getting through, and I don't know how we're going to ultimately stop all of the calls, because guess what? They are going to find a way. So this could, I mean, people said that they expected the proliferation of calls in a mass way. I haven't had it yet on my cell phone, but I'm not, I'm just one of millions. So we're going to see what happens in the next few weeks. It's going to be very interesting. Let's just talk about the FCC. You know, the FCC, as I've said for 12, 15 years, the FCC giveth and the FCC taketh away. The FCC here, Commissioner Pai, on his way out and in his quote duties as a commissioner to, enact laws that follow along with the Trace Act, meaning eliminating bad actors and robocalls, et cetera, decided, oh, we have to, as part of this Trace Act edict, to look at our previous laws, our previous exemptions, to see if they still fall in line. And years ago, the FCC back in 1992 issued an order about its commercial call exemption and said, if you are making a call to a landline, first of all, making a call to a landline via an auto dialer, even if you have one, there's no law that stops you from doing that, okay? You can call a landline all day with your auto dialers, right? Then on the pre-recorded message side, if you were leaving a pre-recorded message side on a landline or an artificial voice message, but you had prior express consent, you're good to go. But the commercial call exemption gave you a pass from that prior express consent. It said, if you're making a commercial call and it does not contain an unsolicited advertisement or marketing within that call, there's no upsell, then you could leave that pre-recorded message if it's commercial only, imparting it's an informational call, and you don't have to have prior express consent, and you could leave as many as you want to, subject to whatever state laws you could be restricted from. But guess what? Commissioner Pai said, nope, that's not good enough. I think we need to put some restrictions in line with my edict under the Trace Act. Really? And conservative Commissioner Pai took away part of that commercial call exemption and said, if you're making an informational call via a pre-recorded message to a landline, then you can only make 3 calls in 30 days. Again, 3 calls in 30 days where you get a free pass. After that, you have to, if you're going to leave a pre-recorded message, have prior express consent to make any calls after 3 pre-recorded message calls. That's crazy. That was not the law. This is the one gift, the one breathing space that that the FCC had given to businesses throughout the country to let them do what they do. Now you need to have your agents on the phone making sure that they continue. And that's what I mentioned, that that this new law is fantastic, but does it really change everything that you're doing within your company? To the extent that you do make or originate calls, then you have to think about, and you do leave pre-recorded messages, now you have to think about prior express consent with respect to calls being made to landlines, artificial or voice calls being made to landlines. And that really is a game changer, because now there's no difference between, in a sense, getting prior express consent to make calls or artificial voice calls to cell phones or for landlines. So that's why I at least advocate for now, instead of doing a wholesale cut, this is a free for all, I'm just going to let my dialer rip, forget about every policy procedure protocol I had. When I'm working with clients throughout the country in developing compliance protocols for whether it's the marketing industry or the informational industry with respect to TCPA, and I litigate these cases on a class action basis, on an individual basis throughout the entire country. Pretty much every single court, I've seen every single judge, I know every single player. Because of what we know and what we're seeing, this is the time to step back, take a breather for a minute, and look at what you do and how you do it. And is this the time to throw caution to the wind? I say no. And I say that if you have a protocol at your company to have your agents ask persons on the phone, is this your telephone number? Do we have permission to call this number? Do we have consent to call this number? That's prior express consent. It's simple. It's easy. It doesn't have to have all these bells and whistles attached to it. You don't have to say via a random and sequential number generator. You just have to get permission, because the FCC said since 1992, the mere obtaining of voluntary consent without restrictions from a consumer gives you the right to leave those pre-recorded messages and to use auto-dialed automatic telephone dialing system equipment to make those calls. Same goes with text, same for pre-recorded message calls. So maybe that whole protocol that you've had in place, that trade organizations, that businesses have had in for years, should stay around, because it has so many benefits and just gives you that extra layer of protection, even if you say I'm not using an auto dialer. So things.
So David, we've got about 10 minutes left, and do we want to try to wrap this in 5 so we can? I see there's some more questions popping up in the chat.
Yes. Okay. Kevin, do you want to ask some of these questions?
Sure. Well, do you want to wrap up your?
Sure.
Yeah.
Kevin, could you go to the next slide?
Yeah.
So we've talked about the artificial voice calls. Just make sure that if you're making calls that you do have the new protocols in place. And remember this is just very tricky, but just like telemarketing calls, if you're going to make more than 3 artificial or pre-recorded voice calls left on a landline, then all of a sudden you have to make sure that those calls that are answered must include an automatic opt-out mechanism. You have to give them an opportunity. For example, if you would like to opt out of calls, please press 1 now. Something to that effect. And a pre-recorded voice message, right, has to include an 800 number that allows the consumer basically, it's a real number, it's a legitimate number. The call can in fact be returned, and they can in fact have easy ways to process out an opt-out request. And it's got to be easy and reasonable, or else you could see yourself running afoul of the FCC's prescriptions. But just in short, Kevin, if you want to ask some of these calls, and then I'll do a quick 2-second wrap up.
Sure. So we have, how are the car warranty robocalls violating TCPA or traceback, or how do the new rulings allow these types of calls to continue?
Well, just like a car warranty robocall that you get, many of those calls that you do get, I am presuming from what I know from myself, are probably made without prior express consent. They are a marketing call. Therefore, that call is subject to the do not call list to the extent that your numbers are registered there. And those robocalls could continue, because what they're going to say is, I'm not using an auto dialer, but they have to say, okay, I'm not using an auto dialer, but can I make this call? Is the number that I have on the do not call list, am I scrubbing those numbers that I want to call against the do not call list to make sure that I'm not making calls that are prohibited from a marketing standpoint, okay? And that's on the do not call side. The do not call side does not affect informational calls, but the car warranty calls are generally not informational calls because they have an upsell as part of their pre-recorded voice.
So here's another one. Does either the FCC December decision or the Facebook case affect who has to use the forthcoming reassigned number database. I don't think the December decision does, like expressly at least. But as to Facebook, I mean, my understanding of the reassigned number database is that the call originators basically have to utilize that database to make sure that, you know, they are not calling a reassigned number. Now, my assumption is because the court narrowed the ATDS decision, you know, that certainly limits their liability, but, you know, because they can call a broader range of parties if they're not using an ATDS. Any other thoughts on that one, David?
Yeah, just to add very quickly, is the reassigned number database going to be the panacea and the cure for all? I usually look at everything with a glass half full. Facebook versus Degweed, absolute glass half full. It's a fantastic decision for, quote, industry. It really is. It's the game changer until something worse comes out. But very quickly, with the reassigned number database, people are skeptical of how it's going to work. It does have its limitations, even the way it's built and what information is going to impart to someone, whether it's going to give you the information and the answer you truly seek. And if you do use it in the proper way, then you will get that benefit of the safe harbor in case you do call a reassigned number that the database said is not a reassigned number or gives you the indication it's not. It's really not that clear. They're not going to specifically tell you if the number, in fact, was reassigned. There's some complications with it, and the rollout's going to be very, very interesting. But look, with the Facebook case, you may not be using an auto dialer, and if you're using an auto dialer, making an informational call, then you may not have to use the reassigned number database for certain types of calls that you do make. But when you're looking at pre-recorded messages, I think game over. You really should be using the pre-recorded message database.
All right. Can I hit the enforcement stuff real quick, David?
Absolutely.
All right. Super quick to wrap up, and then we'll get some other questions. Enforcement, hot topic. There were a number of enforcement activities, FTC, FCC, DOJ in 2020. I'm not going to cover all of them, but toll-free deals, Globex, Global Voice Com, all by different agencies, all under different authorities, state AG enforcement actions. Bottom line, there's a coordinated enforcement effort underway. It's going to continue through 2021. The FTC has expanded its enforcement jurisdiction to include VoIP providers despite common carrier exemption. A lot of folks are looking at the role of gateways, the voice providers that are letting or transiting this traffic into the United States. Because of the industry traceback group, which was something we didn't talk about today, the bad actors are finding it really hard to hide. When I started the ITG years ago, it would take us weeks to complete a traceback. They can do it in hours right now. Acting Chairwoman Rosa Marcel continues to view robocalls as a priority issue. And to that point, in March, she announced an anti-robocall agenda, $225 million forfeiture order. So John Spiller and Jacob Mears are on the hook for a lot of money. Whether they can pay it is an open question. 6 C&D letters to domestic and international voice providers. They had to stop the identified traffic in 48 hours and establish mitigation plans within 14 days. Otherwise, providers would be able to downstream, could block all their traffic. Formation of a robocall response team. 51 staff members at the FCC across 6 bureaus are going to be focused on that. The acting chairwoman also sent letters to DOJ, FTC, state AG. She wants to work more with them in the coming year. So enforcement is going to be a top line issue in 2021. So we've got like 2 minutes left. Let me hit one question. How does a voice provider authenticate, verify a call that originates outside the US? That's going to be a two-step process per the second report in order. And basically what I mean by that is, first, that voice provider is going to have to see if that foreign voice service provider is in the database. If they're not, they can't take the traffic. But if they are, let's assume that gateway provider stir, shake, and compliant. My assumption is they're just going to put a C-level attestation on it and send it on its way. Does the FCC require that all terminating carriers use analytics to identify and block or label robocalls? Again, the blocking and labeling of robocalls is optional for providers. They're not under an obligation to do it. However, if they do decide to block robocalls on the terminating side and on the at the network level, they do have to use analytics in order to do that. And what else have we got here? David, do you see anything that you might want to hit?
I think answered. I think we answered most of the questions that were in the chat. I picked up most of your questions, Kevin, and I think you hit most of mine.
Can I hit one other question that came up?
Sure.
What does certification mean? Great question. That's going to be part of the database. The FCC, there's a public notice that is likely imminent. But what I'm envisioning is whoever has to file a certification, they're going to have to certify that they've either deployed stir shaken or that they have a robocall mitigation plan in place. That pending public notice will flesh that out. All right, we're right at noon, David.
Yep, we are. Thank you. Thank you so much, everyone, for attending today. I know it's not the sexiest topic in the world, but so much going on. It's amazing, and I've never seen the FCC. I think Kevin could agree with this. That never seen them more active. Thank you so much, Stacy. Thank you so much, CFCA, and as always, my partner in crime, Kevin Rupy. Always a joy to work with you, my friend.
All right, likewise, David. Thank you, CFCA, and thank you, everybody.